We don't need that anymore. That case is dismissed. On the record in the matters of the people of the state of Michigan versus Kamarion Kajar, Letitia Clinton, Daya Dennis, and Karia or Karaya Parker, that is. This is 24-03636, 3637, 3638, and 3639. Council appearances, please.
Good afternoon, Your Honor. Matt Nagel for the people.
Good afternoon, Mayor. Please, this honorable court, Kareem Johnson, on behalf of Mr. Kajar, who's seated to my immediate right.
Good afternoon, Your Honor. Joseph Yang on behalf of Ms. Daya Dennis, file number 243639FY. She is present to my right.
Attorney Goodrich from the Public Defender's Office here to represent Ms. Parker, who is seated to my left.
Please the court, David P. Carter Jr. on behalf of Ms. Clinton, who is present sitting to my right.
Today was the continuation of the exam. My notes indicated that we were going to continue and that there was a possible witness that you were going to call, Mr. Carter.
That is correct, and I did notify the party prior to today that I would not.
That you will not be calling any witnesses.
That
So,
is correct.
no defense witnesses, correct?
No, Your Honor.
Oh,
Nothing on behalf of Ms. Dennis.
And nothing on behalf of Ms. Parker.
okay. So then we just need to proceed to argument.
Thank you, Your Honor. So
I'm sorry. You turn that off.
It's loud.
You can turn it off.
Your Honor, the testimony in broad brush strokes for what happened on December 10th, 2024. The victim in this matter, Ms. Love, was in her residence where she had shared with the father of her children. She was lawfully present following a reported domestic violence incident in which her boyfriend was taken into custody and she was left home with her children that following day. That following day, the defendants here related to the victim's boyfriend came to the house, and on the admission of one of the defendants with the intention to physically remove the victim from her residence where the children of the boyfriend also resided. Testimony on that day shows that with respect to defendant Cameron Kajar, that according to the victim, Mr. Kajar was one of many people outside in the front of the apartment. He was knocking on the window to the apartment. He was indicating to the victim to open the door, making various threats, calling the victim certain names, all in an effort to get the victim to open the door. The victim saw the defendant, indicated that she was not going to open the door, and was fearful for her own safety with respect to the actions of this defendant and the others, as she hid her children in a bedroom and locked the room before she was able to call 911. With respect to home invasion count 1 for Mr. Kajar, this would be breaking and entering. First, the defendant broke into a dwelling. It does not matter whether anything was actually broken. However, some force must have to have been used. In this case, the testimony is that after knocking on the glass window, that the front door was kicked in by this defendant. Second, that the defendant entered the dwelling. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body in the dwelling after breaking, that is enough to count as an entry. In this case, with respect to kicking in the door, after the door was kicked in, the defendant was seen inside the apartment by the victim. And I believe that the defendant, well, that comes later. But the defendant was seen inside the apartment by the victim in this matter. And third, that when the defendant broke and entered the dwelling, that he intended to commit the offense of assault. Criminal jury instructions for assault indicate that as a definition, first, the defendant either attempted to commit a battery on a complainant or did an act that would cause a reasonable person to fear or apprehend an immediate battery. Second, that the defendant intended either to commit a battery upon a complainant or to make the complainant reasonably fear an immediate battery. And third, that at the time the defendant had the ability to commit a battery or appeared to have the ability or thought he had the ability. And in this case, the victim, Miss Love, was certainly in fear for her own safety, so much so that she hid her children. She was receiving multiple threats from not just Mr. Kajar, but everybody who was on scene at that time. And then later we have an admission that there was an agreement with the party that it was their intention to remove Miss Love from the residence. So that would certainly qualify as an intention to commit a battery or to make Miss Love feel that she was in danger of an imminent battery. So therefore, the people would be asking with respect to Mr. Kajar that count 1 be bound over. With respect to counts 2 and 3, beginning with count 3, there was testimony from Officer Paul that when he arrived on scene, I think he was the first officer on the scene at the time. He was still talking to people, I should say he had just started speaking to people to try to figure out what was going on. A person indicated that the apartment he was looking for was the address in question here. As Officer Hall approached that person, he wanted to talk to that person. He was seeking to do a pat down, a Terry pat down, which officers are lawfully authorized to do. Mr. Kajar immediately started to refuse orders from the officer. The officer was able to determine ID of the defendant, that was Mr. Kajar. He was warned that he would catch a felony for refusing to obey lawful orders by the officer, who continued to do so, was taken into custody by the officer, who was wearing his uniform. He also arrived in a Lansing Police Department marked vehicle. Once Mr. Kajar was placed in the vehicle, the testimony also indicates that he was kicking on the inside of the squad car enough so that the door was seen to be separating from the car. It is true, however, that asked on testimony whether or not any other damage was visible to the vehicle. I don't think any of the officers were able to testify that they could see any dents or anything like that. But they were able to hear Mr. Kajar kicking inside the vehicle forcefully enough that the door was moving while it was secured on the vehicle. So the people would be asking that for people be Kajar, that this case be bound over on all 3 counts. With respect to Dea Dennis. Dea Dennis was one of the people seen inside the apartment by the victim. I believe Miss Dennis was the one that the victim was unsure of this person's name, but she did recognize Miss Dennis as being one of the individuals who was located inside the apartment on the day of this incident. Here again, entering without the theory of home invasion, entering without permission. First, the defendant entered a dwelling without permission. Second, that when the defendant entered the building, she intended to commit, in this case, the offense of assault. And third, that when the defendant entered or was present in or leaving the dwelling, another person, in this case, was lawfully present. And again, Miss Love was lawfully present in her own residence, which she had shared with her boyfriend and their shared children. And then later, when police officers were arriving, in this case, it was Officer Vanderwerf had testified that when he arrived, he also was trying to speak to individuals present to get information as to what was going on. He made contact with Miss Dennis. In speaking with her, he was trying to get her to stand in a position where he could be seen talking to witnesses, since there were only a couple of officers on the scene and there were many other people on the scene, officers doing what they could to make sure that the scene was secure for all parties involved. Ms. Dennis refused to comply with any of the lawful orders provided by the officer. The officer, who was dressed in his fully dressed in his Lansing Police Department uniform and arrived in a Lansing Police Department vehicle. Ms. Dennis refused to cooperate with orders and was warned that she was going to be receiving a felony if she refused to comply. She continued to and was subsequently arrested for resisting and obstructing a police officer. With respect to Ms. Clinton, here again, the testimony was that Ms. Clinton was I think she was one of 3 defendants with Ms. Dennis and Ms. Parker to enter the apartment from the back door. So again, Ms. Dennis entered the apartment without permission of the lawful resident, in this case, Ms. Love. She entered with the intent to commit assault. The testimony is, of course, that as she was entering, along with everybody else, a number of threats were being made. An argument ensued between her and the victim. Prior to her entering the apartment, once again, the victim had to hide her children because she was at fear for her safety and the safety of her own children. And while the people were in the apartment and coming into the apartment, the victim had to barricade herself with her children in order to call 911. So here, clearly, with respect to the definition of assault, the victim was in reasonable fear of an imminent assault carried out by Ms. Clinton while she was inside the apartment. Felt that she had the ability to do so, and was fearful for her own personal safety. And of course, third, while the defendant had entered or was present in the dwelling, while Ms. Clinton was present inside the apartment, Ms. Love was lawfully present therein. Therefore, the people would be asking that this case be bound over against Ms. Clinton on count 1 as charged.
Okay, let me just. As to Ms. Clinton, again, give me the third element that while the defendant broke and entered the dwelling,
And
she committed what?
oh, that would be second. This would be she had committed or intended to commit the offense of an assault. And once again, the assault being that the defendant either attempted to commit a battery or did an act that would cause a reasonable person to fear or apprehend an immediate battery. And in this case, forcing their way into an apartment, which they were just told by the occupant that they were not allowed to enter, I think would cause any reasonable person fear for the person's safety.
Yeah, but we just can't just arbitrarily put allegations of the intent to assault. So as it relates to Ms. Clinton,
Well,
what specific facts were placed on the record that went to demonstrate that she was there with the intent to commit an assault?
well, I think that the testimony was that Ms. Clinton intended to remove Ms. Love from the apartment. And then as I get into my factual basis for Ms. Parker made an admission to the police that it was their intent when they arrived there that all of them collectively were in agreement that they were going to remove Ms. Love from the apartment.
The testimony that I have from the officer was that Ms. Clinton said she went to retrieve her son's property.
Ms. Parker, when she spoke
Ms.
to.
Clinton, not Ms. Parker, what Ms. Clinton said. And that's what the officer testified, that Ms. Clinton said she was there to retrieve her son's property.
Yeah, but I don't think Ms. Clinton's going to try to incriminate herself in an assault, but Ms. Parker.
What do you think Ms. Parker would incriminate herself?
It came out during cross-examination. There was a question as to why a person would turn themselves in for a crime that they were committing when the police arrived. I actually find that question quite relevant and particularly disturbing in this case because for at least 3 of the defendants in this case, they felt that what they were doing to try to force their way into somebody's living space and forcibly remove them was perfectly acceptable. To walk
I don't
around
find it a
feeling
troubling
like
question. I think it's a relevant question. I think the issue is that these people don't know the law and they think they can get engaged in self-help when you believe someone's in your house and that they don't understand that the law states that if someone's in your house unlawfully, you got to do an eviction and you can't evict them yourself. That's what I think. That's why I think if this happened, why they would be so forthcoming with officers as to what they were doing. That's the only thing I could surmise.
But I think it's important to point out that none of these defendants lived there. This has to do with somebody else's property that none of these people had anything to do with
No,
residing at that.
But I know that's to Ms. Clinton, it's her son, and her son's in jail, and he's the only person who's on the, well, his name is the one that's lawfully on the lease. Because the, Ms. Love made it very clear, and I quote, "She not on the lease, she don't live there."
Well, if that may be relevant in a civil matter with respect to who owes whom for what rent or who has.
I'm not
rights to
talking about that.
property.
I'm talking
I'm
about if you are the owner or you possess some property, can you give someone else permission to go to your property and get your things? You absolutely can.
I think if I were to be arrested for beating my wife and then send my mother to the house to drag my wife out of the house.
That's not what I said. That's not what I said.
It's the same fact.
That's not what it's not. You just changed what I said. I said, can I send someone to my house to get my things, not to go assault someone? Can I send someone to my house to get my things? I lawfully can do that. And so as it relates to the testimony that the officer said that when he asked what was going on, that she reported to them that this was her son's house and that there was a threat to his things and that she was there to get her son's property. I'm not talking about what Ms. Parker said that she would, the purpose for which she was there for.
Well, then with respect to Ms. Parker, Your Honor, the people would be asking that she be bound over to the circuit court on count one, as Ms. Parker did explain to the police that she was there to forcibly remove Ms. Love from the property. She knew that she was entering without Ms. Love's permission, but that she did so anyway.
I'm not really talking about Ms. Parker right now because I think you've already, my question was specifically, and that's what I asked, about Ms. Clinton, because I'm trying to understand what was the allegation of the unlawful offense that she was going to commit once in there. And so to be clear, you're basing it off of a statement that Ms. Parker made, and you're now applying it to Ms. Clinton.
That because it's my recollection of the testimony that Ms. Parker informed the police that it was all of their collective intents to remove Ms. Love from the property.
Remind me of what officer gave that testimony?
It was either Mr. Vanderwerf or Lou. I think it might have been.
I don't think it was Clue. Was I just reading Clue? Let's see.
No, you're correct. It was not Officer Clue. I'm sorry. Looks like Irwin. I beg your pardon.
Irwin.
It is Officer Irwin. That was the February date. This is the third day of this exam.
Sorry, they have no writing over there, and I can tell them you said Officer Irwin.
Yes, Your Honor. That was that February date.
Okay, you can continue.
So the theory, obviously, Your Honor, just being that that the statement of one of the party explaining what the agreement was between all of them, there's a reasonable inference that Ms. Clinton was part of that agreement, and the people would argue that it's more of a question best left to the jury to determine whether or not Ms. Clinton actually had that intent on that day. But with respect to the testimony offered by the officers and the way these defendants are charged in this account, that there's at least a probable cause basis to continue with this matter in the circuit court as charged on all four defendants.
Okay, Officer Irwin was able to identify Parker and stated that Parker gave a statement that they went to get Malaysia Love out of the apartment. But she didn't say who they was. She didn't say they all.
I think that was, is it the February 20th date you got there, Your Honor?
I don't date my notes. I just say who said what.
I'm trying the best I can remember to that. It was my understanding that that was attributed to all of the party, but then again, the way I understood it doesn't necessarily mean that's the way it came out, but that's how I had understood it.
Irwin further went on to say that Kajar, Parker, Dennis entered the apartment. Doesn't even say anything about Clinton in his statement.
Miss Love testified about Miss Clinton coming in. I believe Miss Clinton is the mother of the person who's.
I recognize. I'm not saying that she wasn't there. What I'm saying is that Irwin didn't. My notes from Irwin was not that Parker said Clinton was there to commit an assault, is what I'm saying. So to use that one isolated statement from Parker, which one is Parker again? Parker. That's Parker.
Is that Parker?
Okay,
Oh, excuse me.
correct. To use that one isolated statement, correct. To use that one isolated statement through Irwin, and of course, this is literally a question of fact as if that's actually what was said. So that's his interpretation of what it was said. If the attorney had played the body cam, who knows what would have said, what was actually said. But they didn't do that. And so she's saying that the officer says, why are you here? Well, we're here to get her, or I'm here. She could have said, I'm here. I don't know. That's a question of fact. But he never even testified that her statements were inclusive, I should say, of Clinton specifically. But what the other officer did state was that Clinton made her own statement, I'm here to get my son's property. So that was the only question I had. I'm not asked, I don't need you to go into any more detail about what Parker's purpose was.
That's just, that was my recollection of the testimony.
Okay.
From what I was looking for.
Sounds good.
Thank you, Your Honor.
Thank you. Defense.
Definitely, thank you. I'll start with the resisting obstructing charge against Mr. Kajar.
Okay.
So our position that the court should reject any bindable motion as to that charge. We believe that first the court has to determine whether or not there was reasonable suspicion or probable cause to detain Mr. Kajar at the moment the officer put hands on him. And I think that there was not, certainly was not probable cause. The information the officer had was that some individuals were engaging in a alleged break-in. Now, it's funny that the officer, based on the testimony, thinks that some woman and her children is trapped in an apartment unit, hiding in a bedroom, according to the testimony. But instead of running to the apartment unit to render aid to this person who was supposedly surrounded in his apartment unit, he stops to interact with the individual who he admits has a trash bag in his hand, is taking out trash. So, if the court determines that he had reasonable suspicion that criminal activity was afoot, at that point, he had no specific articulable facts that Mr. Kajar was engaged in any criminal activity. And Terry allows for, him to investigate, but Terry doesn't require my client to cooperate with that investigation. And when the officer tells him to come here, he says, no, I want to stay right here. That was well within his right. And so now when the officer goes to put hands on him and put him in handcuffs, that elevates the seizure to an arrest. And at that point, there was no probable cause to arrest Mr. Kajar for any offense. After this investigation, Mr. Kajar is taken for the home invasion. Now, with the home invasion, there can be several things that are true at the same time. But regardless of how the court believes or finds those different factors, still don't think Mr. Kajar can be bound over. Ms. Love, based on all testimony, may have been lawfully present. Okay, she was there the night before. She clearly was a guest. Kids were there. She was in this relationship.
And she said she paid a utility bill.
Right.
I don't dispute that she's lawfully present.
So the issue becomes, can anybody else give Mr. Kajar permission to enter that residence? And if they can, the people can't satisfy the breaking and entering, that unlawful entry portion, even at exam. And there's been.
I agree. I don't disagree that someone could give, I think I said that, someone can give another person permission to go into their property. I don't have anything on this record that said that permission was given to your client to go there.
And that would be burden shifting. It's not on the defense to prove that they have permission to enter that residence. It was on the government to prove that anybody, that nobody with permission gave them permission to enter. And the legislators made it very easy for them at preliminary examination stage. They got a whole court rule that allows them to use hearsay to, put on proofs of entry, possession, authority to use. They didn't do so. So it's our position, it's my position that it is not on me to prove that Mr. Kajar had permission to enter that residence. It was on the government to prove that he did not. And they did not prove that he did not, in my opinion, even by probable cause.
Well, I think there was some questions posed to the person who was lawfully present. And then there was also, I think, under Officer Irwin, there was a question that was posed to Parker, to which he said at no time were they invited to the property. So
Well, I'm sorry, let me cut the court off.
at no time were they invited into the property. And your client is alleged to have kicked the door in.
So they're not invited to the property by Miss Love. But Miss Love is not the only person that can extend an invitation to somebody to come to the house.
Yeah, but can you give someone permission to kick a door in?
Yeah, my parents can give me permission to go to their house in South Michigan.
When someone
kick the
else is
door.
lawfully present there?
Yeah, her rights, Mrs. Love's rights to the home, and her rights are, I don't want to say imaginary, but they're not rooted in any possessory interest, right?
Why aren't they?
Because she's not a leaseholder.
She pays a bill there and she lives there.
She's not a leaseholder. That apartment is governed by contract law.
Right,
And
but
I'll
she,
explain court.
right,
landlord
but
tenant rights.
she has a right, she has possessory interest there.
She was an invitee there.
She's
and-
more than that. She's paying a bill.
and she's paying a bill.
And the children that she bears with the person who's supposedly on the lease are there with her.
But her, whatever possessory rights the court believes she has, she does not have the right to exclude people that another lawfully present or leaseholder invites over.
Well, it's an allegation that a lawfully present leaseholder invited them over. That's still an allegation, because we didn't have him here saying that.
but we don't have any evidence that he didn't invite them over. So as much as I may hate my wife's friends, I can't put them out of my house, or because my rights to the house don't supersede hers.
Agreed, but we don't have anything here that from him that says I gave this person permission to go and kick my door in.
I agree, Your Honor. So now the issue becomes whose
So that's a
burden?
question.
Yeah, whose burden was that? It wasn't our burden. It was the burden of the government to prove that they were excluded from entering the location on that day. And they did not do so, in my opinion. Or does any other questions? I mean, that's.
I don't have any more
Fine,
questions.
thank you.
Thank you, Your Honor. On behalf of Ms. Dennis, I guess I just want to clarify a point that the people had made earlier about that Ms. Love wasn't familiar with Ms. Dennis. Ms. Love was familiar with Ms. Dennis. It was Ms. Parker that Ms. Love originally said she didn't know, but then changed her testimony later and said that she didn't know.
I recognize that, yeah.
So I just want to make sure that was clear. And just based on that, I'd ask this court to not find Ms. Love's testimony credible. She changed her story about knowing Ms. Parker. That's a very simple thing to either you know this person or you don't know this person. She stated in her testimony, she admitted that she has anger issues and that she was actually in an altercation the morning of her testimony. I would join in Mr. Johnson's recitation as to the home invasion first, as to Ms. Dennis. She is a sister of the leaseholder there. And again, the people have not brought anything to say that she did not have the right to be there. I understand the court's position on that, that there was no testimony for that, but I join in Mr. Johnson that it is the people's burden to bring that, to say that there was no other authority that Ms. Dennis or anybody else could be there at that time. And actually, I would submit that Ms. Love was actually on her way out of that home. She testified that she was there to get her stuff to leave, to go to her dad's house and stay there. And so whatever altercation happened the night before prompted her to leave the home. So she was leaving the home. And so based on the information Ms. Clinton received and that she provided to the officers was that that's why they showed up, mom and the sister, Ms. Dennis, to protect the property of her brother. And so again, we pointed this out already. Mr. Love was not on the lease. The police did not do any search of the home to make sure of bills, anything of that nature. She said she may have paid bills, but that there was no testimony as to what the agreement was, how long she's supposed to stay there, anything that somebody could pay to couch surf for a day or two. That as far as a link was not
I
provided.
think she testified as to how long she had been staying there.
She says for about a month or two that she was there.
Yeah, I think since October, and we know the law in Michigan, if you let someone stay for a certain period, you gotta lawfully evict them if they don't want to leave on their own. She did state unequivocally that when they said, "B, open the door and get the F out," she said, "I'm about to leave anyways." So it sounded to me like she intended to not be residing there anymore, that she knew that she was not going to be residing there.
Correct. So my submission is that though, yes, she may have lawfully been there, that day she was gone. She knew she should not have been there because the person who invited her to be there was no longer there. Wherever he's at, I'm not gonna, but he's no longer there, so she needs to leave. So I would submit to the court that she was not lawfully there at that time, maybe previously, but not at that time. It's in point in time that Ms. Dennis was there. So therefore, I'd ask that this court not bind over on home invasion first as to Ms. Dennis. As to count two, the resisting and obstructing. We heard the testimony, Ms. Dennis was simply standing on the sidewalk. I hate to use this colloquial term, but standing while black. She was literally just standing. The officers testified that they did not have any reasonable articulate suspicion. No descriptions were provided over the air, just that a home invasion was happening.
I'm sorry, you said that she was standing while black?
No, just a colloquial term. She was literally on the sidewalk, just standing on the sidewalk when officers showed up.
Well, I think I asked questions too about, specifically, I think Ms. Dennis. Because I wanted to know why. I personally had an issue with how quickly everyone was cuffed.
That's
And
correct.
so I asked the question. And essentially, the officer said that everybody that spoke with Kajar was cuffed. That's how it went down. So, and that your client was being uncooperative in their investigation.
So first, there needs to be reasonable articulate suspicion for detainment. And then, but officers did not testify into anything. Just because they were speaking to Kajar, that does not rise to reasonable articulate suspicion. They can speak to him. They just said they were speaking. They didn't say that there was any testimony as to what she said that would have risen to reasonable articulate suspicion just because they're speaking. The officers also testified there were numerous people out there at the time. The scene kind of got chaotic. I mean, at that point, who do you arrest then? Either you arrest everybody, or you don't arrest
Everybody that
anybody.
speaks to Kajar, that's what they said.
Well, I submit this point, does not rise to reasonable articulate suspicion. If just because somebody's speaking to them, let's say if if his attorney happened to be there and said, hey, don't, just said something to him, would they have arrested his attorney as well for being
It's a
there?
wonderful argument.
Yeah, so just because somebody's speaking to him, it's not like they obstructed the officers, got in front of anything. Then no testimony was that. Literally, they wanted to talk to him. They didn't want to talk to him. Ms. Dennis has a right to not talk to officers if she's not detained or under arrest. So there was no reasonable articulate suspicion for detainment. There was no probable cause for an arrest. There was no information over the air as to a description that would have matched Ms. Dennis, that would have allowed them to have reasonable articulate suspicion that Ms. Dennis matched that description. None of that was. Officers testified they did not observe any criminal activity of Ms. Dennis. So that does not rise to articulate suspicion or probable cause. Therefore, her detainment and a subsequent arrest at that point was unlawful. So therefore, as for the resisting and obstructing, I'd ask this court to not bind that over and dismiss that because based on Ms. Dennis's Fourth Amendment right to be free from unreasonable search and seizure, the officers unlawfully arrested her without reasonable articulable suspicion or probable cause for that. Thank you, Your Honor.
It's interesting that you make the argument that that your client had the right to not speak with the attorneys because, I mean, to the officers, because one of the officers, I think it was Officer Blue, said that was part of the reason why they were detained. It's because they refused to talk when they were being detained. And I think you had to be reminded about their right to remain silent. Who's next?
Your Honor, on behalf of Ms. Parker, Your Honor, we had 5 different witnesses testify in this preliminary exam. Officers Clue, Vanderwerf, and Hall all testified that they didn't really have anything to do with Ms. Parker and really weren't involved with her in any way, leaving only Officer Irwin and Ms. Love as far as witnesses regarding her on that day. Officer Irwin is the officer who took the statements from her. He testified that she told him that they went to get Ms. Love out of the apartment. He did not state anything regarding that they had any intent of using violence or forcibly did it, as the prosecutor insinuated. He also testified that Ms. Parker informed him that she walked through an open door to go in the apartment. Ms. Love, she testified that the apartment was leased by Brea Sanders and that he had the ability to give others permission to enter his apartment, and that she was planning to leave the apartment later that day. She also testified that as soon as she saw, I think it was a couple of people on the outside banging on the door, that she locked herself into the bedroom, and that she entered and she locked herself in there before anyone ever actually came into the apartment. So she testified that she never actually saw Ms. Parker. She didn't see her outside before anybody came in. She testified that she didn't see Ms. Parker, and the only thing that she saw was Ms. Parker kind of walking out the door jam area, right as kind of stepping right out through the door when she came out of the room. She testified that she never heard Ms. Parker's voice, that she was never yelled at by Ms. Parker in any way, and that they never had any type of physical contact. So, Your Honor, when I look at the elements of this offense, clearly we don't have a breaking and entering involving Ms. Parker, as the jury instruction for that clearly states that entering a dwelling through an already open door without using force does not count as a break, which is the only testimony we had about how she got in there. If we were to go with the entry without permission, as Mr. Johnson stated, the prosecution failed to provide probable cause that they didn't have permission to enter the residence. As Ms. Love herself testified, the apartment was leased to Mr. Sanders. He was the one who had the ability to give permission to other people to enter it or not. We did not get any testimony from Mr. Sanders. Therefore, the absence of that essentially shows that this is not entry without permission. Beyond that, they also have to show that it was done with the intent to commit a crime or that the crime was committed. Well, we know that a crime was not committed based on the testimony of Ms. Love. As she said, she never had any type, as far as an assault goes, she never had any type of contact with Ms. Parker inside the apartment. There was nothing physical. There was no swinging arms. She never saw her.
He said she never saw her in the apartment. That I know because I have it noted in my notes.
Yes. So then I guess the other question is, well, did she intend to commit some type of a crime while in the apartment? And I don't think, first of all, based on her actions, that can be inferred. I think if we look at just the statement, it said they went to get her out of the apartment. That does not require physical violence. The first thing they said was get out of the apartment. I guess the hope was that verbally that she would leave the apartment. As an attorney, certainly know that there's better ways to go about getting an eviction than trying to get something than just showing up and yelling at somebody to get out of the apartment. However, that's not necessarily a crime, intending to commit a crime by showing up to talk to the person, even if in a hostile way. Ms. Parker seemed to be kind of the person in the back. Again, no efforts to assault either Ms. Love or any of the other officers that we saw from Ms. Parker. So based on all the circumstances here, Your Honor, I would ask that you deny bind over for home invasion first degree regarding Ms. Parker.
Thank you, Your Honor. As far as Ms. Clinton, I would echo all the arguments that all the other attorneys have made, the defendant attorneys have made. Also, start off with any statements that Ms. Parker made cannot be attributed to my client. And not use co-defendant statements against another defendant because they don't have the right to cross-examine. So as far as goes to my client, this is a probable cause here, which means the prosecution has to bring probable cause on each and every element, not a gut feeling, not a gut feeling that they weren't supposed to be there. It has to be probable cause. And I would echo what Mr. Johnson has indicated, that you cannot shift the burden to the defendants by saying, you show that you had permission. That isn't how it works. We know that Mr. Sanders was the leaseholder of the apartment. Matter of fact, Ms. Love indicated it was his apartment. I wrote it down, big old
With his
letters.
cousin.
It was his apartment, which means that he has the ability to give other people permission. As the officer indicated, at least one of the officers indicated that Ms. Clinton said she was there to get her son's property. Well, if we can infer things or we have a gut feeling, that seems very reasonable that a mother would come to her son's apartment and try to get his things so that they don't get destroyed. We also heard that Miss Love has a temper and she likes to break things. So that all sounds pretty legit to me. The prosecution, as far as it goes to my client, has failed to put any evidence on whether or not my client had permission to enter and had not had permission to enter into that apartment. And I'd ask the court not to bind over on my client. Thank you.
Thank you. Re-argument.
No rebuttal.
You don't want to address the burden shifting argument that each of them has brought up.
Well, with respect to the burden shifting, this person wasn't there on this day. He doesn't have any.
Who's this person that you're talking about?
This would be, I forget his name. It's Miss Love's boyfriend who was removed the day before, and at the time of this incident, I think was subject to a no contact order on bond with some court.
How does that have any bearing on the prosecution's burden to prove that?
Because Miss Malaysia Love was lawfully present in a place where she resided at the time. She was lawfully present at the time because she.
But she's not the only person that lives there. So we know from the testimony of your witnesses that Ms. Love was there, and I agree she was lawfully present.
Right.
But we also know that there's leaseholders. There are two people that are not her. And why could not one of those two people give her lawful permission for someone else to go over there?
I think on the totality of the circumstances in this case, the way that people showed up and started threatening Miss Love, and she was well within her rights for her own personal safety to not allow people to come in if she felt that she was being threatened based on people's conduct.
I think her statements was that they were banging on the door and said, open the door and get the F out. That's what she said they said. She never testified that they threatened her.
Well, I think communication goes further than just merely words that are spoken, facial expressions, body language.
How could she see their facial expressions if the door's closed?
Mr. Kajar was in the window, tapping on the window, speaking to her directly, and she could see Mr. Kajar over here, speaking to her through the window. And tones of voice, the way people are aggressively coming, prior contact, which Ms. Love had talked about. I mean, the totality of the circumstances, the way the situation was being communicated to Ms. Love, as far as she was concerned, is that her safety was in dire danger. And so she was within her right to refuse people to come into the house, to give her a chance to get her and her children out.
But I'm not addressing her having the right to refuse people in. She doesn't have to open the door, but that doesn't mean she can stop them from coming in because she doesn't own this property. She's not a leaseholder, correct? And so could not the owner give his mom the key and say, here, go get my stuff?
I think, again, under these circumstances that.
No, answer my question. Could an owner of if I rented a property, can I give my mother the key to go in there and get my things?
If your intention when you arrived there was to calmly go in and get the things for the person.
Why do you have to be calm? Why? If I said someone's over there and they're threatening to damage my stuff, you have to be calm to go get my stuff?
Yes,
Why?
because the person inside has a right to make sure that their own personal safety is defended. I mean, in this case, if she were to allow them to come in under the way people were behaving on that day and time, she would have been, according to this hypothetical, subjecting herself to potential forcible harm. She could have been seriously hurt. As far as she was
Based on
concerned,
what?
based on the people's tone of voice, conduct, the words they were speaking to her.
Her words were that they said, get the F out.
They're
They didn't say, she didn't testify at least, that they threatened to touch her in any way. She said that she did not initially see Miss Parker in the house. She said, they said, B, open the door and get the F out. She said, in response, I'm about to leave. She says, Kajar kicked the door in. And her response again was, I'm finna leave anyways, and she began gathering her stuff. She never testified that they threatened her, or that once the door was open, that anyone approached her, swung at her, hit her. She didn't testify to that.
She did testify that there was an argument between her and the others, that she had to hide her
An
children,
argument is not illegal.
but she had to hide her children. And again, with respect to assault,
From an argument, you should always hide your children from certain communications, but an argument is not illegal. And an argument is not an assault. People get in arguments all the time. And you don't, where in the law does it say you have to go get people's stuff calmly, otherwise you're violating the law? You said they have to, the only way that she can go get her son's stuff is if she does it calmly.
yes, Your Honor, and I stand by that.
What if the other person's not calm?
Then they should, like adults, separate them from each other until the person who's lawfully inside the home.
That's not
leaves, as
based
she
in
said.
law. That's your personal opinion. Your personal opinion is that if they're gonna go and retrieve the things, then she needs to be calm. She doesn't have to be calm. She can't be assaultive.
But if a reasonable person believes that the conduct, the behavior, the tone of voice, the messages that she is receiving,
I would have to first believe Miss Love is reasonable then, correct?
which I think would be a question left best up for a jury. in this case.
Well, I don't have to, because I saw Miss Love myself. I don't have to leave it to a jury to determine if she is a reasonable person or if her actions were reasonable, because she came before me. It's my time to make the determination. And she presented herself and she explained her behavior, her past behavior, that she's someone who has an anger problem. That's not reasonable. She said she don't live there, that she was leaving anyways. And I don't think she ever disputed that they didn't have the right to come and get the stuff. I think when she was asked, did she threaten or make some threatening comments on the social media, she said it had something to do with something else, but not this incident. That's my recollection of her.
The social media thing, there were so many different.
It was a lot of moving parts.
I can't remember.
My also recollection of her is that we had to pause this presentation. I've never had to pause a case for that long to allow her to calm down. She's in the hallway threatening to fight. She is right here. My court officer had to sit in between her and this person wasn't saying anything to her at this time. And so I can make a determination if I believe that she operates as a reasonable person or not.
I think the law also requires a reasonable person in her position on December 10th, 2024, whether a reasonable person in that apartment, not necessarily this witness, but a reasonable person in that apartment would have perceived the situation the same way.
I think a reasonable person in that position probably would have left the apartment if you had the person arrested and you're in their apartment, no?
Not if that's where her children also resided.
Well, she said
Where
she
else
was leaving. That's not what she said. She said she was leaving and she was going to reside at her father's house.
But she hadn't left yet.
She
had
was
every right
gathering
to
her
be there
things.
in that moment.
Yeah, she was gathering her things. But there was a possible threat of destroying the person's property, but she said it was related to another incident.
Your Honor, the people have made their motion.
Okay. I am going to go back. I need to look at a video from the first iteration of this to confirm something. We're going to take a brief recess so I can do that. put it on in there for me. All right.
Sure, about 10 minutes or so. Yeah.
Oh, no, I just want to have more. I couldn't fit that too big. Lost a couple pounds. Squeeze back in.
Excuse me.
So always take long with all these terms.
Carter, yeah, no, that's where I was really loud. Carter made a great point on a big issue I overlooked. Trying to use Parker's statement.
I had thought of that, but it's my client, so it doesn't help.
Yeah,
We have that murder, I'm helping Steve Cornish on a murder trial with Bill in a week, and he had to split the case
Yeah.
for that reason.
yeah,
I honestly wasn't real familiar with that until that just came up a
the,
week or two ago.
the whole theory on the assault thing, that's the thing that I think this is hanging on. I could see that going away on everybody because of that.
Well, you look, your police report, she said that she got, they're all hit.
The fact that she changed her statement though isn't great for her credibility. And this isn't the only reason I'm worried about this case is because it's 4 defendants and I've already got 2 of them mixed up. I'm glad I forget which one you corrected that, but I'm grateful to corrected which one it was, she can remember. But like, no sympathy for the victim trying to do this because she's really just. I mean, and then like all the stuff that happened that morning, the first I was tracking. I thought, man, it's terrible. That she's been harassed like this, and then it comes out that she's posting shit on Facebook anyway. So like, is this because of court, or did you call these people out? And I'm sure it was any of these people were involved. I think it's just completely different people. Well, because that's the other thing I was trying to. I was just like, hey, who was there? And she's getting mad at me that I didn't already know. Because I was trying to figure out, was it one of the defendants or? But it's just.
What you trying to do, see?
Who, me?
I've never been a case of my clients to act reasonably. Are you kidding me? Act reasonable? Of course they're not reasonable. That's why we're here.
The question is to whether or not they entered to commit an assault, I think is what this whole thing. Well, I don't know, maybe it's hanging on other things, but that's what I thought it was hanging on. Because I don't have a strong case on it. I mean, I've got the case I just argued. That's as strong as it is.
When it was charged, you had a different police report, you had
Right,
different
yeah.
facts.
But again, like, the judge is right. The credibility of the victim, like in this case, like it's an issue. It is an issue. Hey, you made a great point. I was just telling Luke, a great point on a big issue I overlooked.
What's that?
Parker's statement about your client. I can't do that. You're 100% right about that thing. Without looking into like the minutia of that particular issue, I just think you're 100% right. I can't do that. So I don't think your case is getting down over. If any of them are getting down over, I'm sure it's not yours.
Well, I hope not, but
My suspicion is that it was the question, well, apart from the fact that you're right, I can't use Parker's statement, and if not for Parker's statement, I don't think I had anything else come in other than the argument. So
yeah, but
even
that's
that's
like
weak.
she said, it's an argument.
it's weak, yeah. That's the assaultive issue. I thought was the thing. That this is what things hanging on. And then like the whole question with how, like the RNOs, I guess you guys getting dismissed as well. Because you're right.
I could be guilty of bank robbery, but you got a probable cause for you.
Man, the cops are just trying to control a situation with people running around all over the place. But whether or not it rises to like, a supportable RNO, I don't know either.
But that's the thing, like what I do, and is I listen to the 911 call, and I watch the body cam, right? And if your information from 911 is basically we got this trapped woman in an apartment,
Yeah.
being confronted by family members of the boyfriend we just locked up yesterday, and I get out the car, I don't give a damn about the guy on the street with the garbage bag. I'm getting to this apartment complex.
Well, I think it depends on how you look at it. Because what if that person on the street with the garbage bag is related? I mean, like,
But he doesn't know that. I
Well,
mean,
right,
if
so
he
he's gotta-
knew, if the
so he's gotta
officer
ask.
knew that,
Right, so he's got to ask.
Yeah, but he has no duty to answer. That's the point there.
Well, that's what I'm getting at, is that from my point of view, and of course I'm biased, right? I'm looking at this from-
Yeah, we're both biased. I'm
But-
biased on this side, you're biased on that. side.
Right, but I'm just saying that
We're
I think,
supposed to sharpen each other's sword.
I think there's probably probable cause, whether or not it would stand up to trial, I don't know.
No.
But like I'm saying, like I can see the RNOs going away. I would not be shocked. I wouldn't be upset by it.
His priority, and his priority when he first arrived.
Well, see, I see what you're saying, but I mean, it's gonna end up the way it ends up. And I'm not gonna do that. Put quiet, I don't-
I'm gonna lose power. I have a cord.
Just trying to find some place to plug it in.
Yeah, this is my last stop, so.
Yeah,
There's a plug right there.
Well, I was going to do work, but I can't.
It's Friday.
My program.
It's Friday. Let's get this over and done with. Is that specialty court over there? Is that what everybody's getting?
No, it's weddings.
Oh, weddings. Oh, okay.
Friday afternoon. So we can get it.
Oh, I forgot.
Did you do a motion of quash on Hayes?
Leonard Hayes?
Yeah.
No, I did a motion to quash. I did a motion to suppress the cell phone
Okay.
GPS.
Because he got it mixed up then. My client said that you did a motion, but the pinging of the cell phone. I don't know, even if you're successful on that. I don't know
Well,
if it
I was-
prevents anything.
I was trying to get the body thrown out. I
The
told
what?
the body. I told him that if she grants the motion, it's only gonna affect the body, right? The video of you, and
Yeah.
what happens still comes in. So I told the case to get dismissed, but I mean, she was, yeah, he was there. She kept focusing on the exigency. And I'm like, okay, but,
Wait, there's no exigency.
well, she's saying that she said because he told the girlfriend that they took him to the hospital, it was reasonable for the police to believe that he may still be alive. And so that was the exigency. And I'm trying to say, okay, Your Honor, even if we disagree on the prong one, there's still the exigency plus inavailability to get a warrant. So even if you find that prong, you still have to say that they had no ability to get a warrant, and they did. They're emailing the phone company for the pings, right? So they get information from the phone company. So they would have had this.
Did she make a ruling?
Yeah, she's not.
Oh. Yeah. So she hung her head on that, she thought the guy was still alive.
Yes,
Tyler was still alive.
and in need of medical assistance.
But so she's as gullible as his girlfriend is, because clearly the video shows he wasn't alive.
Right, it's rolled up in a carpet.
Yeah.
And carried over the shoulder and thrown in the trunk. I mean, that's as dead as you can get.
Yeah,
Sending in the
I
right
don't
direction.
know. I mean,
Well, I told him, I said,
the
you know what?
video is pretty disgusting.
I told him, you know what, it's gonna be hard to, when you got a chopped up body in garbage bag, it's gonna be hard to get a judge, especially a new judge, right?
Yeah,
To, you know,
I know,
throw some stuff out.
I know. Did the affidavit for the warrant, did it say that they thought the body, that the person was still alive?
There was no warrant,
Oh, there was no warrant,
not for the cell phone.
not for the pinging?
Yeah. They just called and, so like the state police have a form, like I got one and I scolded dismissed, the prosecutor is about to dismiss it. they use a form where you have to list what the exigency was. And when we got the form, and when the prosecutor looked at it, she was like, okay, yeah, this is bullshit. I'm dismissing, it's the case. I guess here, they're not requiring the police to submit any type of form or anything. The police they decide we got an emergency. They call the cell phone company, and the cell phone company gives it up.
Really?
Yeah.
I didn't know that.
It's not even like they dial in 911 and the 911 system is doing it. Because I had an argument about that in another jurisdiction. To me, that's still a search. If your 911 system is tracking my location when I call 911.
All right. That's not it. That's why I hate continuations. It's like,
So the videos were up this whole time?
Huh?
The videos from the last?
no, the recorder keeps all the videos,
Okay.
so we got to pull it up in the system.
I didn't think it would stay up.
And
that long.
because
That would've
we're
been
up
very
here, I can't see like facial expressions, or you can see all of it on the video. Got it. Okay, sounds good. You have everybody? No. We're missing
No, once
somebody.
we gain.
Mr. Yang's not here. That's fine. I need to get my water.
Your Honor, Mr. Yang is currently on the record finishing a matter up in another court.
Yeah, I'll stand with Mr. Yang with the consent of his client. For the ruling,
Oh,
I assume
okay.
the court's not gonna ask any more questions.
I'm not asking any questions.
You might not stand with Mr. Yang for the ruling.
Is that a yes? Okay, sounds good. Okay. I had the ability to go and refresh my recollection and fill in some gaps in my notes, because this is a exam that spanned the matter of 3 separate iterations, but I think we began this back in February. And then at least in the second iteration, there were a lot of disturbances and breaking up a portion of the complaining victim's testimony mainly, which was essential. And so I needed to go and review that again. So for the benefit of the charged individuals here, the purpose of this examination was for the people to put forth sufficient evidence that would establish that they have probable cause sufficient to charge you with the felonies that you've been charged with, and then sufficient probable cause. Let me back up. Probable cause that a felony was committed, and then sufficient probable cause to charge you each individually as the person who committed those felonies. So this is not a trial. They don't have to prove each element beyond a reasonable doubt. The court is the sole determiner of any credibility issues of witnesses at the time of the exam. And then the court also is in the position to weigh the government's likelihood of establishing guilt at trial, or whether there's evidence that raises reasonable doubt about the defendant's guilt. And so we had testimony of multiple witnesses over the course of this examination. And Mr. Nagel has already gone over the criminal jury instructions and the elements of the charges. So first taking Mr. Kajar, who's been charged with home invasion first, and malicious destruction, and then a police officer assault. And then we have Ms. Clinton. She's been charged with home invasion first. We have a Kajar Parker, who's been charged with home invasion first, and then we have a Dea Dennis charged with home invasion first, and then police officer assault. When the court, I think I've already made it clear that I did have concerns initially about how quickly individuals were placed in cuffs. I don't think that the way that the scene was handled, in my opinion, was reasonable. But that doesn't mean that it rises to the level of a lack of probable cause. To be charged with the home invasion, you actually there has to be enough probable cause as to each of these elements. And as it relates to some of you all, the elements are just not there. For Mr. Kajar, the testimony of Miss Love, particularly, because essentially she's the one who contacted the police. She called the police, according to one of the officers. And at the time that she contacted the police, she, through dispatch, and I think this came in through Vanderwerf, said that dispatch provided information that a caller stated a woman named Clinton and multiple others were trying to gain access to the home. And so that was what brought the officers to this location. When Miss Love was questioned during her direct examination, she testified that on the date in question, and that again being December 10th, 2024, at the area of 3822 Wilson in Lansing, Michigan, that there was a lot of yelling and commotion outside the door. She said the mom was yelling. We've later now identified the mom in this particular case to be Miss Clinton, the mom of Miss Love's child's father. And so she said that she saw Mr. Kajar. Love says she saw Mr. Kajar knocking on the window. Mr. Nagel asked Miss Love, did he say anything to you? And he said, bitch, open the door. And she then testifies that the sisters in them kicked the door in. When Mr. Nagel further tried to clarify, because it was very difficult to understand what she was saying, even as I went back and re-reviewed it just now. There was multiple times that I had to rewind and turn the volume up because she wasn't speaking in a form that was making it easy for anybody to understand what was going on. So Mr. Nagel reasonably had to rephrase the question to try to understand what she means. And so she says they kicked the door in, and you specifically, Mr. Nagel asked her, by they, were you able to see who kicked the door in? To which she unequivocally pointed at Mr. Kajar and said, him, Mr. Kajar kicked the door in. She did not state that anyone else kicked the door. And she said, I saw Kajar at the door when the door was kicked in. And so as it relates, at least to a malicious destruction of property, I think that we clearly know that I think I made it clear that I believe that she was lawfully present. Ms. Love is lawfully present there. Do I believe that someone else could have given permission for Ms. Clinton to be there? Absolutely. But I've only heard any information here that would lead to the fact that Ms. Clinton told an officer that she was sent by her son to come get things. I didn't hear anything that Mr. Kajar was sent by the owner, that Ms. Dennis was sent by the owner or the person who possesses the lease, or that Ms. Parker was sent. The testimony I heard was that Ms. Clinton received allegedly some permission from her son to go. I do not believe that Mr. Kajar was given permission to kick the door in. Maybe he went to assist Ms. Clinton if she was there to get some things, but I don't believe he had a lawful right to be there. I also don't believe, based on what was brought in, that there was a right or permission for him to kick a door in. And I don't believe that he had a lawful right to then enter. So she states that he kicked the door in, that he entered the property, that there was a lot of yelling. And when asked, did you hear him say anything other than let you in? She denied. She said that she did not see Parker in the property until after the police arrived. I was unequivocal as well. She stated, and the other issue is for Ms. Parker, Ms. Clinton, and then Ms. Dennis to be charged with a home invasion, then they must have done something to break. And there's no information on this record that either of them did anything to break. That the breaking allegedly was done by Mr. Kajar, and that after which the other parties, with the exception of Ms. Parker, entered. And so that doesn't allow me to bind over on home invasion as it relates to Ms. Clinton, as it relates to Ms. Dennis, or Ms. Parker. I can only bind over as it relates to home invasion first to Mr. Kajar. So that will be bound over. I do believe there's sufficient probable cause as to bind over for that. As it relates to the police officer assault, again, I absolutely disagreed with how the scene was handled or maintained. I don't know how chaotic it was, but I heard from multiple officers that there was a lot of moving parts. It was chaotic. I heard testimony of officers immediately arriving and just taking people and putting them in cuffs, not knowing really what happened. I think that there was a better way for this to be handled. But that doesn't mean that these officers violated policy or the law because they didn't handle this in the best way. The officers do have the right to place people in cuffs as a detention. And I think we asked further questions about why or what justified them placing these suspects into cuffs if they're just trying to sort out what was going on. I think where the issue comes into place is as they were trying to cuff. I mean, there's overwhelming testimony as to Mr. Kajar's resistance and kicking doors, and they could hear him kicking inside of the cruiser or whatever as it relates to him being taken into custody. And I think it was Officer Hall that testified that Kajar was uncooperative, yelling and swearing, and as they were trying, and that he had to try to assist Vanderwood had to assist Hall, that is, in taking Kajar into custody because there was a struggle that went forward. The officers were responding to a complaint of a home invasion. They are there for a lawful purpose. They're in uniform and fully marked vehicles and cars. I do understand, I believe Vanderwood maybe did not identify, he was forthcoming. He don't believe he identified himself as an officer, but I think it's unequivocal, and based on the other testimony, that Mr. Kajar knew the officers were reporting to this scene because of a call, because he was the one who told them where to go. So he knew that these were officers here looking to see what was going on. And he should have been more cooperative with the investigation. And anytime you're struggling with an officer trying to secure a scene and put you in cuffs, then you're hindering their ability to perform their lawful duties. And so for that reason, as it relates to Mr. Kajar, the police officer assault will be bound over. So the complaint as charged as to Mr. Kajar will be bound over. Ms. Parker was never even seen in the house until the police arrived. That's dismissed. Ms. Clinton, I believe Ms. Clinton had permission to be there. I don't believe she needed to be calm. However, I will say this, since we're on the record, if I could have gotten a break from Miss Clinton, she would have been bound over, because when I went and replayed the testimony of Miss Love, she did testify that Miss Clinton and the sister, after entering the property after Mr. Kajar kicked the door in, were pushing her. And so that is an assault. However, you were charged with that. You were charged with a home invasion, and I don't have enough for home invasion, so that's going to be kicked. And then lastly, as to Ms. Dennis and the police officer assault, resist. The testimony, I believe, of Officer Clue was that when he arrived, he was told to put Miss Dennis into cuffs because it was an uncooperative exchange that she had. And we asked him, who told you to place her in cuffs? He said another officer told him to place her in cuffs because she was uncooperative. He didn't know what that meant with her being uncooperative, but when he took her or went to place her in cuffs, she clutched her arms to her chest. In an attempt to not be restrained in cuffs. I don't know exactly what it means that she clutched her arms to her chest. The only thing I can assume is that officers are telling you that they're going to cuff you and you go like this. It's the only thing I can assume, which would cause them to have to use force to put you in cuffs. And albeit I believe that this situation could have been investigated without detaining possible suspects in cuffs, and I do believe that Miss Dennis was a reasonable suspect under these circumstances. But I don't believe that she was cooperative with their investigation, and maybe had she been cooperative, she would not be charged with a police officer assault. I do believe that there's sufficient probable cause, though, based on the testimony, that she enabled their ability to lawfully perform their duties during the investigation when she clutched or clenched her arms to her chest while they were trying to place cuffs on her in a detention. And so for that reason, she will be bound over as it relates to the police officer assault, count 2, count 1 as to Ms. Dennis is dismissed. Bind over date is May 14th. That's the date that the circuit court gets to file from the district court, and not a date that either Ms. Dennis or Mr. Kajar needs to appear in the circuit court. Their next court date will be a pre-trial, and that will be a date that their attorneys may advise of after the circuit court receives the file from the district court. Does either, or does anyone have a question at this time?
No, Your Honor.
Nothing on behalf of Ms. Dennis.
On behalf of Ms. Hart.
Okay, as it relates to, oh, sorry, there was 4. Okay, as to Mr. Kajar, there is a bond that was 5,000, 10%, a 10 p.m. curfew, unless with parent or guardian, must attend school. What school are you attending?
Every high school,
You're a senior?
yes.
Okay. Let's see. And not within 2,000 feet of the alleged victim. That will continue. And then we have Miss Dennis, 3,500, 10%. And no contact with the alleged victim. That will continue. Any additional matters for the record?
Not for the people.
Nothing on behalf of Ms. Dennis, Your Honor.
None on behalf of Mr. Kajar, Your Honor.
Nothing on behalf of Ms.
No,
You're all set. Thank you.
thank you.
Oh, if Ms. Clinton and Parker want to wait, I have a copy of the dismissal.
Thank you, Your Honor.